Well, hello, everybody. I am Randa McCown. I am the Director of Affordable Housing for Leading Age Southeast. I recognize some names, so hello to all of my old friends and hello to all the new friends. We are going to talk today about the Violence Against Women Act and specifically as it pertains to developing the emergency transfer plans for HUD multifamily properties. Make sure that this is advancing. Hang on, it has stopped advancing, you guys. Oh, there we go. You all have seen this. I'm not going to read this page to you. You probably are here because you saw the objectives. So just very few minutes on brief basics of VAWA if you're not familiar. It's actually been signed into law since 1994, so it's been around for a while. And even though it is called the Violence Against Women Act, it does not apply to just women. So make sure that you are providing protections for whatever's necessary, regardless of gender. And this particular piece of law has been reauthorized several times. It's been through several changes through the years. I listed some changes there where either a change or a reauthorization has happened. And the most recent change was that we had an update to some of the VAWA related forms in February of this year. We're going to talk about those as well. On your screen, you have a list of property types or funding types where VAWA is explicitly applies to you. So if you see your property type listed here, you need to be listening more intently to this. However, there's a thing that says that you need to make sure that just because your program is not listed here, it doesn't mean necessarily that it does not apply to you, because there's a caveat in law that says that any federally funded program needs to be adhering to VAWA guidelines and providing VAWA protections. So also as a clarification, we know that there's a lot of layered financing out there. That's sort of how you make a property work, is finding a whole bunch of different ways to pay for things. And so when you have layered financing, it's inevitably going to create a situation where you're going to have some different guidelines to follow. And so HUD has said when you have a layered property that might have different guidelines to follow, that the victim that is receiving the VAWA protections or remedies can choose to use the protections or remedies under any or all of those particular programs, so long as the protections and remedies are feasible and permissible under each of the program statutes. So keep that in mind if you are a blended property. I added this slide into your handouts just because it did give you hyperlinks to these particular notices. It's not that these are the only notices on VAWA protections for HUD multifamily programs. It is that the 2017-05 is the most recent notice that has been released by HUD as it pertains to VAWA protections for HUD multifamily programs, but it is not all encompassing. And so you do have to use that notice in conjunction with HUD's final rule for implementation that was released. It's kind of funny. It's called the HUD's final rule implementing VAWA 2013, but it wasn't actually released until December of 2016. So there was about a 3-year delay between when federal law said you have to do this and HUD got around to making its rules for it to implement it. So use these two documents in conjunction with one another. As a reminder, the goal of VAWA is to make sure that if there is someone who is a victim or a survivor of a VAWA covered crime, that we are not denying them housing because they are dealing with consequences of being a victim or a survivor, that they're not going to be evicted and lose their housing, they're not going to lose their assistance, and that they will be able to transfer to a safe unit. So make sure that you continue to remind yourself of the goals of VAWA, even though some of these situations may get, I don't know, complicated, I guess, and burdensome. And speaking of VAWA covered crimes, this has evolved over time. Currently, it is to cover dating violence, domestic violence, stalking, and sexual assault. So those are what's currently considered a VAWA covered crime. But HUD has clarified, and I tried to make this as flashy as possible for you all. HUD has clarified that survivors do not have to contact authorities like the police or have to initiate legal proceedings like getting a restraining order against an abuser or a perpetrator in order for them to qualify for VAWA-related protections. The statute has no such requirement, and HUD has no such requirement, and instead it allows survivors to provide self-certification about the VAWA-related incidents. We're going to talk about where there's going to be an exception to this particular rule. But since today is specifically about the emergency transfer plans, let's tackle that. And some of the things that I've said we're going to talk about are going to be interwoven into it as we talk about the emergency transfer plans. So a VAWA emergency transfer plan is a required document. It's not optional. You are required to have it in place, and it should have been adopted no later than June 14th of 2017. If you are sitting today at June 18th, 2025 and have not done it, let's talk, because we need to get that in place for you as soon as possible. And one of the things that's a little bit confusing is that your emergency transfer plan as it pertains to VAWA is not required to be in one continuous or inclusive document. It can actually exist in a multitude of different documents that you are already using, like your tenant selection plan or your house rules, so long as all of the required contents are covered somewhere, people know what they are made publicly available, and your tenants are aware of them. One of the key elements of VAWA housing protections are emergency transfers, and that is what allows a victim or a survivor to move from their current unit into what they deem as a safe, available unit if they are in fear for their life or their safety. And then making your emergency transfer plans, I have a quick little note here. Make sure that it is available upon request when it's feasible, and make it publicly available. And one of the things we have learned in HOTMA, if you have been following that at all, which I'd be surprised if you were not, is that there is no definition of what public means. And so whatever your property defines as making it publicly available, then you can follow that definition. But the important thing to remember here is that we are making sure that any victims or survivors have access to the information so that they know what they can do to try to keep themselves safe. So, like I said, they're required. They have to allow a tenant that's a victim or a survivor of a VAWA covered crime to transfer to a safe unit. And here's some things that have to be in place. Okay, the tenant has to request the transfer. So I know that a lot of people in housing have great hearts. We really do. We have servants' hearts, and we want to help where we can, because there's always a need just for help somewhere. It's not to say that you cannot suggest that they move. It's just you want to make sure that you're not steering them to move. And so you want to make sure they're aware that they need to ask for the move. And the tenant has also expressed that they reasonably believe that they are in harm or in threat of imminent danger, or they have been a victim of a sexual assault or a sexual crime that occurred at the property within the previous 90 days before they request the transfer. So what are the required elements of an emergency transfer plan? I'm going to try to go through these a little bit quickly because we're going to talk about them in more detail individually. So they need to allow internal transfer to take place immediately if a safe unit is available. You have to allow them to seek an internal transfer as well as an external transfer. The terminology that the VAWA final rule uses is concurrently, but it just means at the same time. Make sure that that language is specifically in your emergency transfer plan, that you will allow that to happen concurrently. You have to describe the policies for assisting a tenant in making an internal transfer. When you don't have a unit immediately available to transfer them to, how are you going to try to keep them safe in the meantime? You have to describe policies for assisting a tenant also with an external transfer. It does not mean that you have to go find them a unit. It just means that you have to describe your policies when it comes to how you're going to make sure that they get to a safe place, whether it's in your property or off your property, as quickly as possible. You're required to list documents that are needed to request an emergency transfer, define a tenant's eligibility for the emergency transfer, define the measure of priority given to a tenant or applicant that needs some sort of preference or emergency transfer related to a VAWA covered crime, and then outline your very strict confidentiality measures that you're going to make sure that you keep the information related to a victim or a survivor in complete confidence. So let's talk about internal and external transfers. Internal transfers, I feel like this is sort of like common sense, but just in case, internal transfers refers to them moving somewhere else still within your property or your contract number with HUD, your HUD contract number. So you want to make sure that if they're transferring, you don't make them undergo a new application process because they're just transferring like any other transfer. It just happens to be a transfer that's related to a VAWA covered crime. So policies related to internal transfers. You want to describe how you're going to handle the VAWA related requests for those internal transfers when you don't have a unit immediately available. Because let's face it, we don't always have a lot of turnover. Sometimes we have no turnover for extended periods of time. And so that puts you in a very precarious situation trying to find a safe unit for someone to go into when you're having no turnover. Because it's not like you can go kick somebody out to have a vacant unit to move someone in that can, for a victim just because of VAWA regulations, right? That does not make sense. And that's not allowed either. So make sure that you're describing some things you're going to do when you don't have an immediate unit available. You also want to make sure that you're describing any applicable additional priorities that the property might give to make sure that if you have a vacant unit, how you're going to determine who gets to move into that vacant unit. What do I mean by that? And this is also described in our required content when it talks about the measure of priority that you'll give. What we mean by that is if you have a vacant unit, you have someone who is on your internal transfer waiting list that has a medical need. You have another person on your internal transfer waiting list that has a reasonable accommodation request based on disability. You have someone on your internal transfer waiting list that it needs to move to a different size unit because their family size changed. You also have an applicant at the top of the waiting list so you've got a whole bunch of different people, including this VAWA person that needs a transfer. So just of that, what I described, that's 5 different possible people who could move into this one vacant unit. And so what you have to do, not just in your emergency transfer plan, but also in your tenant selection plan, is you have to give a weighted priority to determine amongst all possible occupants, how are you going to prioritize them to determine who gets to move into that one vacant unit first, okay? So that's what that means. External transfer, obviously, it means you're transferring them off of your property to go live somewhere else that they consider safe, and you would move them out of your property, like an official move out. And what you want to do is make sure that you're describing policies related to how you're going to support that person. Again, it does not mean that you have to go and find the unit for them, and you don't have to fill out their applications, and you don't have to, do anything on that level of detail. What you do have to do is talk about how you will assist them. This may be something as simple as making sure that they have a list of organizations, women's shelters, the police, maybe a homeless shelter or a local organization that might specialize in domestic violence support. Like you're going to make sure that they have contact information for that person or those organizations in your area. Maybe you, depending on the situation, maybe you let them use the office telephone to make the calls. I mean, that's not a requirement, just sort of some suggestions. But no matter what, you're required to outline your policies to help that person move out of your property if that is the best option to keep them safe. External transfers into your property. That's the other piece of this. So you need to develop policies of whether or not you're going to accept someone who's living at a different property. They are experiencing, as a victim or survivor, one of the VAWA covered crimes, and they are asking you, do you have a unit I can move into on an emergency situation, which means they would be skipping people on the waiting list. This is not a requirement. And that's one of the things that seems to be a little misunderstood about VAWA regulations is when it comes to accepting external transfers onto your property, you're not required to prioritize them or give them a preference to skip people on your internal transfer waiting list or your application waiting list. But you can, if you feel strongly about it, you can absolutely make those people a priority. You can assign a preference to them so that they're able to get housed and into a safe place sooner. You may also have policies, and again, this is a big may, it's not a must. You might make arrangements with other owner agents to facilitate moves. If you are in an area that has that as an option and you have lots and lots and lots of different housing providers, you might want to come up with some sort of understanding or agreement or arrangements amongst the groups. I know a lot of the housing managers have like quarterly meetings where they sit down and they talk to each other. That's maybe something that you want to put in your policies. Maybe it's outreach organizations that we talked about. Either way, you got to figure out how to either help someone living at your property move externally to somewhere safe, or someone externally outside your property trying to move on to your property as their safe place. As a reminder, these need to be happening at the same time if you don't have a unit immediately available on your property. Here's another reminder. Keep records related to VAWA transfers and VAWA information and reports of VAWA protections completely separate from your tenant files. Why, you may ask? Well, there have been situations, and I know of one on a personal basis, where if a household lives together, anyone in that household can come in and ask to see their tenant file, and you provide it. You know, they're not allowed to leave the office with it, so you keep it into, in the office setting. But if they want to see something in their tenant file, you provide it to them. Well, in this particular situation, someone was trying to escape a domestic violence scenario, and they went to the office and they asked for help, and they took down, wrote down a bunch of stuff, and they gave them some information, and they were trying to help them get housed as quickly as possible somewhere safe. And they put what they decided on was she was going to go stay with a friend. And so she said, I need to make sure that I'm able to get a hold of you if I'm able to find somewhere else for you to go, or if you find somewhere else for you to go, let me know. And she jotted all this down and put it in the tenant file, and the perpetrator or the aggressor came in, asked for a copy of the tenant file, found out where she was living, and he went and he actually killed her, and he also killed the friend that was trying to help her. So it's really, really, really important that you keep any information related to VAWA incidents not in the tenant file, because you are not required to hand that over to another household member that might be the perpetrator. Okay. Luckily, with regards to our emergency transfer plans, HUD has given us some help, which is great, right? So HUD has developed what they call an emergency transfer model plan. They call it HUD form number 5381. It was recently updated in February of 2024, and the HUD final rule, this has been around since 2016, is where we started seeing this model plan. But there's some things you should know about using the model plan. And in all the years that I was doing management and occupancy reviews, and I was reviewing these emergency transfer plans, I saw a lot of things that were missed on a regular basis. And as a reminder, if you have layered financing and you might have HUD financing on top of maybe rural development or USDA financing, or maybe LIHTC financing, tax credits. LIHTC has no model plan. IRS has not released one, but rural development has also released to get some help developing this emergency transfer plan. Now, one of the questions that I used to get asked a lot is, can I use HUD's emergency transfer plan model to develop it for my other units, like tax credits or some non-HUD related program? And the answer is sort of. To the extent that those LIHTC or those non-HUD units have some sort of HUD assistance attached to them, then you follow the VAWA final rule and the emergency transfer plans that were developed by HUD. Now, if on the other hand, there is no HUD assistance tied to your units that are not HUD specifically, then you need to go seek guidance from the administrative authority. If it's LIHTC, it'll be the IRS. If it is rural development, you go to USDA. But you need to follow whatever governing agency is in charge of that particular type of financing on your property. But there's nothing preventing you from, if there is no guidance, like in LIHTC, using HUD's guidance to make it applicable to your LIHTC units as well. Here is some things that I saw missed a bunch when reviewing emergency transfer plans. So if you're going to use the HUD model plan, there's a requirement in the plan for you to attach a list of local organizations that offer assistance to victims or survivors of these VAWA covered crimes. And it was almost always missed. They would have these a list of the national things that are already in the plan, and they would miss the step where you had to attach a list of local organizations. So make sure that you gather that, collect it, and attach it to the model plan or to your HUD emergency transfer plan. And it is okay to go and seek these, establish these memorandums of understanding or an MOU with some of these organizations that might be able to help a victim, whether they're your tenant or they're trying to become your tenant. Always be aware of state-specific VAWA laws. I know that we have a wide audience here that may be in lots of states that are not in Florida. So make sure that you are aware whether or not your state has established any particular provisions related to VAWA protections. And if they have, make sure that those are included in your emergency transfer plan. And implementing the emergency transfer plan may require provisions to other or revisions to other controlling documents like your waiting list policies, your tenant selection plan, and your house rules. So make sure if you're making changes to any of the things related to VAWA anywhere that you make it everywhere across the board. So the 5381, it's a great start. It really is. I'm so grateful that HUD was like, hey, we're going to try to help you out and give you some guidance here and make it a little bit easier for you. Yay. It was updated in February of 2025. How do we know that? It has a new expiration date at the top. You see that in the little blue box. And it added some instructions. And so it specifically tells you inside the green box in the new version what it's supposed to do. And it also gives you instructions for how you're supposed to handle it. And part of those instructions are fill in the blanks. And I saw this a lot too. People would just sort of print the model plan and they would just hand it to me. And it wouldn't have any identifying features for their property. And it wouldn't have any of their specific policies. And I would sort of go, well, it's a good start, but here's what you need to do to make it actually a usable, compliant plan. This one's no different. That was released in February. You still have to go and fill in the blanks. You still have to go in and fill out property specific information and property specific policies that you have decided. For example, the policy to give preference to VAWA is not a requirement, and you may, in all of your rights and authority, decide not to give preference or priority to VAWA victims and survivors, but you have to outline that you are not giving priority or preference to those people. I think this is just sort of a recap. You have to adopt the an emergency transfer plan. You can use HUD model 5381 if you want to. But it's only general. You still have to make changes and updates and make it very personalized for your property if you choose to use the model plan. Make sure that you are fully addressing and changing things across all of your documents, including TSPs and house rules and anywhere else that you outline things that are related to transfers and VAWA protections. And just a reminder, doesn't have to be all in one place. It can be across all of those documents as long as you hit all of the required contents. So what do you have to modify specifically? If you want to use the HUD model plan, the 5381, what's missing, right? We talked about some of these already, but you have to go in and add the measure of priority that you're going to have for each particular type of person that could occupy an empty unit or a vacant unit. So prioritize the families, define your measure of priority. You have to you have to describe your policies for internal procedures and assisting a tenant who needs it, and describe your policies for external procedures. And there's two kinds of external procedures, right? So external procedures to help your current tenants move off property, and external procedures of whether or not you're going to prioritize someone that is off your property trying to move onto your property as a protective measure. So if you're going to use a model plan,
Brenda, are you frozen or is it on my end?
I was wondering the same.
Okay, yes, I think that she was frozen and has left, so we'll give her just a few minutes to return.
Okay. Thank you.
Sorry about that, everyone. Take a little intermission. Again, if there are other topics or suggestions you have for future housing happenings, you can put those in the chat. A couple folks have emailed me and messaged me privately, and that's great. I really appreciate that. But we'll give her just a few minutes to return. Here we go. She's coming in now.
well, that was fun. Sorry about that.
Hi.
My internet went out, so I was like, oh no. So I had to jump on my hotspot really quickly.
That's okay. Let me make you
reshare.
co-host again. The joys of virtual.
I'm telling you, it's never a dull moment. I gotta find what I did with it. I was in frantic mode.
Yeah, that's okay. Take your time. Take a minute.
Here we go. Okay, let's go back to that. Share that. Go into from the beginning. All right, can you see it?
Yes.
All right, let's catch up to where we were. Hold on. Okay, I think we're here. All right, take into account when you're reviewing your transfer waiting list policies, how frequently you have turnover, right? Do you have a long list of applicants? You may look at it and go, we never have turnover. So it doesn't make any sense for us to prioritize someone moving out, off of our property, seeking solace and safety in our community, because we can't even get people that already live here transferred because of reasonable accommodations or medical reasons, or, whatever transfers are necessary. So look at how your property operates and when you are reviewing your transfer waiting list policies, and then take those things into consideration, because every property is unique when you are developing some of your transfer and preference policies related to VAWA. Again, you are not required to give preference to VAWA victims, whether at your property or trying to move into your property from external locations. But if you want to, you can. Just make sure that you also have it listed in your transfer and waiting list policies in your tenant selection plan, and give priority to who would get it if you had a particular opening. So emergency transfer plans have to detail the measure of priority given to the tenants who qualify for the emergency transfer under VAWA. And they also have to take into consideration Section 504 regulations. So Section 504 is how we accommodate disabilities on our property. If you have a particular vacant unit that comes available, you are working on trying to figure out who's going to move into it, you have to take into consideration Section 504 regulations, because if you have that particular vacant unit that has accessible features that are needed by someone that has a disability related need for that feature. So let's say that someone is deaf and that particular unit already has a blinking light or a doorbell to notify them someone's at their door. And you have someone that's either needs a transfer from inside your property, or you have someone sitting on the waiting list that needs the features of that unit, you have to take that into consideration, because Section 504 of the Rehabilitation Act says first current household who needs the accessible features gets that vacant unit that has those features, right? Second, then you move on to eligible qualified individuals on the waiting list that need that feature. And then third, you might be able to offer it to people without a disability that needs that specific feature. And that might include some of your VAWA. So you can't automatically prioritize VAWA victims or people needing VAWA protections, because there is a layer of federal law that says if that particular vacant unit has accessible features that someone who is disabled needs, they get priority for that particular unit over anybody else. And you take your current tenants first, then your applicants that need those features, then you can move in someone who may not need those features but needs protections. Another thing that is a little bit confusing is when a victim or survivor requests you for help transferring over and over and over and over and over and over and over. And at one point we sort of say, come on, like, you've been through every unit here and haven't found safety. Surely this has to stop. Unfortunately, no. You cannot limit the number of VAWA related transfers. They can ask for transfers into perpetuity, and you just sort of have to go, okay, we'll try again, and be okay with it. So be at peace with the fact that there's no limit to the number of transfers they can request. For applicants, we've talked about this. I'm in the interest of time, I'm not going to reread this. It is also probably in your handouts. For applicants that are eligible for an emergency transfer into my property, do I have to give them preference? No, you don't. We talked about that. You can, but if you do, put it in your emergency transfer plan, put it in your tenant selection plan, put it in your waiting list policies, and make sure that it is you're notified everybody in all your documents that you are or are not going to give preference to someone who is trying to move into your property. All right, so let's talk about transferring and handling those requests. The statute does not specifically address the documentation need. We talked about this at the very, very beginning. There's no required documents that you are allowed to request to prove that someone is a victim or a survivor of any of the VAWA covered crimes, okay? HUD has addressed document requirements for VAWA emergency transfers for HUD programs only, okay? So we're not gonna look at the VAWA statute right now. We're gonna switch over to how HUD has implemented in their final rules and their rulemaking about handling emergency transfers. So HUD says that, and I'm gonna read this because it's directly from their rule. Tenants requesting transfers can submit a written request before the transfer occurs, certifying that they meet the criteria for an emergency transfer under the final rule. And that's really all that's required. Now, to facilitate that, HUD also said, hey, I'm going to give you some help here too. We've developed an emergency transfer request form, also known as HUD Form 5383. You're not required to use this form. It's just a model, but you can use it if you want to and don't feel like recreating the wheel. It's there for you. So if you want to use that as your documentation for a tenant who's requesting a transfer, have them fill out that transfer request form because that's their, hey, I request this transfer. And it also certifies, hey, I meet the criteria for an emergency transfer under the VAWA, HUD's final rule related to VAWA protections. You may, and this is where it gets a little confusing and people start implementing stuff wrong. So listen up. You can accept third-party verification if they offer it to you. You cannot require that they give you a copy of a police report or something from a women's shelter or from some sort of counselor. You can't require that they prove to you that they were a victim of a crime. You have to take their word for it, okay? There's one exception, and I'm going to talk about that in just a minute. But if they offer it to you, you are allowed to take it. You don't have to turn it down. But I want to say to you, if you take it, you need to train yourself and train your other staff that you document this was offered by the tenant. We did not require that they provide this to us, because that way nobody can ever look at you and say, you're not allowed to require this. Why did you require this? Well, you didn't. They offered it, I took it, and notated that it was offered. You can, this is a may, you don't have to, you can require that tenants request emergency transfers to document in addition to this form that they're going to fill out saying, hey, I'm eligible for this emergency transfer, right? You can also have them document what happened. Now, that doesn't mean third party. That doesn't mean a police report or something from a counselor or, a women's shelter. It means that you can have them write down the incident that occurred, okay? And people get confused with that. They read it and they go, oh, well, I can require them to document the occurrence, but the documentation is not required to be from a third party source. The documentation can be from the person, and it can come in the form of them writing down what happened and when and where, okay? And you don't even have to require that. It's a may, it's not a must. If you want to, you can say, this is our policy. You have to write it down and tell us what happened, when and where, and who was involved, all the things. But you can't require it to be third party. So how do you initiate an emergency transfer? The requirements to initiate the emergency transfer need to be included in your emergency transfer plan as it relates to VAWA policies. And it can be verbal. You may have someone, or you may work for a property that says we're not going to require anything to be written down by the victim or survivor, right? How do you document it then? How do you keep track of it? How are you supposed to cover your butt to make sure that you're following procedures? Well, what I recommend is if you're going to accept verbal statements or a verbal certification, in place of them writing it down is, hey, you write it down. You take notes on when, where, what was said, what they requested, all the things, so that there is a trail for it. But you're allowed to require them to write it down. Okay, you can. You don't have to, but you can. And I think that these nuances are what make VAWA so confusing to a lot of people. So if you take a verbal statement, it has to include a statement the tenant requests the transfer because they reasonably believe that there is a threat of imminent harm from future violence if the tenant were to remain where they're at, or they make the statement that there was a sexual assault that happened on the property in the 90-day calendar period prior to them requesting an emergency transfer. Verbal or written, either one. If they make it verbal, I do recommend you turn it into writing, or you can just simply say, I need you to write it down, okay? The 5383 emergency transfer model form, you can customize it. You don't have to use it, but you can if you want to. So you may also request in writing that the victim provide documentation of the occurrence. We talked about that, but that doesn't have to be third party. It could be them saying this is what happened. This is what the new version of the form looks like. This was released in February of this year. This is and it literally says at the top, emergency transfer request for victims of domestic violence, dating violence, sexual assault, or stalking. It has confidentiality information. I do recommend that you sit down and read this yourself, read this with your staff, make sure that people know what's on the form, because it does tell you, you can request an emergency transfer when 1, 2, or 3, and it says, you know, you or a household member are a victim of violence, abuse. 2, you expressly request the transfer. Remember, that's one of the key components is they have to request it. And one of the other 3, A or B is in place. Either they think that they are in imminent danger of continued harm, or there's been a sexual assault in previous 90 days. This is a multi-page form. So I just want you to be aware that I highlighted on the bottom, page 1 of 3. I don't have all 3 pages for you. It's just the first page, so you know what it looks like. Just know that there's more than 1 page. Remember, they have to request it. An emergency transfer request does not guarantee continued assistance or external transfer to another HUD housing provider, meaning if you're helping them move off the property to stay safe, there's no guarantee that you'll be able to help them move into another income-based property. So you need to make sure that you address that in your policies, procedures, and maybe your forms. And then the tenant has to make sure that they meet eligibility or occupancy requirements for the property that they are moving into if they're not staying with you. So here's sort of the cycle of how it goes. Victim requests the protections, you follow your procedures that are in your VAWA plans or other documents, collect information and or documents from the tenant, which is usually just self-certification, and it can be verbal or written. I do recommend that it be written because then it eliminates the chance of misunderstanding if you are the one writing it down, but you're not required to have them write it down. I just recommend that it's a good idea because then it's in their own words and their version, and there's no argument to be had later of that's not what I said. You wrote it down wrong. And then keep the information in a separate location and keep it in a very confidential manner. You know, just the same as we would want for ourselves. If you've been through that situation, we wouldn't want our information kept confidential. We want to give the same courtesy to other victims. So there's a lot of numbers here when it comes to VAWA forms. I've written them here for you because we lost a few minutes. I'm not going to read them. Just know that every form number means something, and we've talked about 2 of those. We've talked about the 5381, the model transfer plan. We've talked about the 5383, the request form for emergency transfer. The 2 other forms, the 5380 and the 5382, you are giving those to the tenant, whether they're victims or not, whether they've expressed anything to you or not. You're giving them at every move-in, and then at what's called every adverse action, meaning if you send them a notice of non-compliance, you attach those 2 forms. If you send them a notice that you're going to terminate tenancy or assistance, you attach those 2 forms. And if you are rejecting an applicant, for every single application that gets rejected, you attach these 2 forms, the 5380 and the 5382. They are attached always. And then in February, HUD put out this 5384. It's new, it's not required, and it's a way to collect data from properties about VAWA incidences. I thought it was kind of interesting, but they have not put it into place yet. They just sort of quietly released it, and it was brand new, but there's no need to worry about it right now. I wanted to show you what each of these forms does look like so that you have eyes on it and you can sort of, you know, have some familiarity with it. Remember, we said the 5380 and the 5382 have to be accompanied with every application rejection, move-in, and any adverse notice of non-compliance or termination of assistance or tenancy. So what those forms are, 5380 is saying, here's the protections for victims that's available to you. Okay, so it's sort of an informational brochure. If you see here, there's a place you have to put some contact information. And again, this is just the first page. This is a 5-page document, so make sure that you are including all 5 pages. Here is the 5382, that second form that you're going to give at every application rejection, move-in, and adverse action notice. Again, you have to enter some contact information, and this is a 3-page form, but this is where they certify that they are eligible as a VAWA victim or survivor. So this is their certification form, okay? So you're giving them instructions of their protections, and then you're giving them the ability to certify that they qualify and are eligible for those protections. That's the purpose of these 2 forms. Again, this 5384 is a new form, and it is for data, emergency transfer data collection. It's not required, and it's something that HUD hasn't even really sent any information out. They just released the form. But it says that this includes if the request is made verbally, even if the housing provider VAWA emergency transfer plans require that it be in writing. So keep that in mind. And then I saw something pop up in the chat. Was it a question?
Yeah.
Okay.
Yep. It's a great question from Judy.
Perfect. All right. So in terms of emergency transfer for 2028, when breaking one household into 2 households, so you're bifurcating the lease, as I understand it, where does the subsidy certification process fall into all of this? Moving a person is one thing, but completing a new individual subsidy certification is another. You're right. If you are bifurcating a lease, generally speaking, the perpetrator is normally going to be evicted. But every PBCA sort of does this differently if you go through a PBCA. When you bifurcate a household, the household that stays, you do an interim recertification to establish that they have a new household composition, and that may include income or assets that are attached to the person that left. So you have to remove that person, the income, and the assets that are attached to the person that's leaving the unit, okay? And then you just do an interim recertification to restructure whatever's left for whoever's staying in that same unit, if they're allowed to stay. And then for the person that, if you happen to have a immediate unit that they can transfer into on your property, then you do an initial certification to move them in because they're already a current tenant. So you're not moving them in. You're just moving that person into a different unit. That's an initial certification, and you establish them as their own household under initial certification, not a move-in. I think that that's what you were asking. And if not, let me know. But hopefully that's what you were asking, and I answered it for you. Here's some steps. I know we're getting short on time, so I'm not going to spend a ton of time on these, but you want to make sure that you are following the right steps. I did include these in your handout so that you can go back and follow them later if you need to, but just make sure that you are, the tenant is aware of their rights, that you have them request the transfer, that you collect some sort of certification that they're eligible for the transfer as a victim or survivor under a covered event, including if it was a sexual assault in the previous 90 days that happened on your property. It's not to say that if they were sexually assaulted somewhere off of your property, then their unit should be considered safe, if that makes any sense. It's specifically in regards to 90 days that happened, 90 days prior for a sexual assault that happened on your property. Make sure that you've got your policies in place about verbal versus written and how you're going to handle that. If the perpetrator lives in the unit, tell the victim when you think that you'll be able to get that perpetrator evicted, and then provide them with local resources that they might be able to temporarily relocate to. Start the eviction process for the perpetrator because, you know, assault is a crime, whether it is sexual or physical, whatever it is a crime, and you should not be allowing perpetrators that live on your property who commit such crimes to stay on your property. And then I started doing that again. Here we go. Follow your eviction processes, notice of termination, They can appeal it. They have 10 days. You have 10 days to conduct a hearing. Just make sure that you are redacting any information about the victim from all documents that might be provided to the perpetrator during this hearing or during their appeal. Make sure you're keeping stuff in a separate file. And there is only one exception to the confidentiality that you can make. And that is what's in their file, right? But you don't want to give away information that's going to put that victim at further jeopardy or further, what's the word, being unsafe. And then provide the perpetrator with your decision in writing after you've held the hearing. If they decide after you've had the hearing, you still have to evict them, then you do it. And if the eviction is upheld in court, you go through the process of an IR to remove that perpetrator. You bifurcate the lease if the victim wants to stay in that unit. And if not, then you move them to a different unit or help them find somewhere until you have a different unit. The goal here, the key here, is making sure that they have a low barrier certification process. If you have ever been in a situation where you have been a victim of one of these covered crimes, you know the emotional and mental chaos that it puts into your life, and it makes it really difficult to do things sometimes. And so you want to take that into consideration and make sure that when you are needing third-party documentation, that it does not cause a barrier. So I told you there's an exception to when you're allowed to require third-party verification, right? That's the exception is when it's he said, she said, it's his word against her word. There's no way for you to know who's the true victim and who's the true perpetrator. At that point, you are allowed to seek third-party documentation by way of lease reports, counselor reports, shelter reports, whatever documentation is needed. The only exception to requiring third-party verification is when you are trying to determine, you've received conflicting information and you're trying to determine what is correct. Okay, so that's the only exception. Documenting occurrences, again, you can use the certification form or you can use one of these documents. It's not an and, it's an or. Any of these will suffice, but you just can't require the third party unless you're trying to just, you've received conflicting information, trying to sort out who's correct. Make sure that you are developing your written policies regarding verbal versus written requests. An applicant or a tenant has to inform you that he or she is a victim and provide you with enough determination to be able to make the determination that they need assistance. You can consider documentation of adverse factors that result from a tenant or applicant being a victim. What do we mean by that? It is not uncommon for victims to use someone's credit card, make them pay for stuff, put things in their name and then not pay for it. They may end up with a bad landlord history because there was always fighting or yelling, or they have damage in the unit because of them, the perpetrator punching walls. And you want to take all that into consideration because it may not be the victim's fault that they have bad credit or a criminal history or a bad landlord reference. And so make sure you're asking enough questions to determine whether the fact that they have bad credit, criminal, or landlord history is a reason not to let them live on your property or move on to your property. Which is why when you reject an applicant, you give them the certification and the, what's the other one? The 5380 and the 5382 forms, so that they know, oh, well, I might be able to still live here because none of this was my fault. I'm a victim. You have to make an objectively reasonable determination of whether that adverse factor is a direct result of them being a victim of one of the covered crimes. And you are allowed to ask for clarification or additional information when you have conflicting information. Here's some timelines. We are so out of time. I'm so sorry. Let me see if I can blow through these very quickly. Response time. If after the applicant or tenant requests protections under VAWA and you determine that you need additional information because what you received doesn't make sense or conflicts with something else, they have 14 business days to respond, but you are allowed to extend that time period if you want to, and VAWA protections can be denied if they are not submitted on time. However, you want to take into consideration that there are factors where they are just inevitably going to miss the 14-day deadline. If they have a concussion from being battered, they might have disabilities, they might have limited English proficiency. You know, there's lots of situations where they might miss that 14-day deadline. So it's not a hard and fast deadline, it's a guideline. So take that into consideration and make sure that you have policies and that you train your staff to make that sort of a soft deadline when there's extenuating factors in place. Your 30-day deadline is if there is conflicting information and you need evidence, you need third-party verification to sort it all out, and you can require that they provide that within 30 days. And this is the only time that you can require third-party verification is when you're sorting out a conflict. Who determines what's safe? Well, the victim or the survivor does. They have to decide what's safe, just like we get to decide for our lives what we consider safe. So make sure that you let them decide what's safe. Are you required to pay the moving costs related to a VAWA emergency transfer or application fees if you're trying to help them move off the property? And no, you are not. Make sure that your policies outline that so they're aware you will not be paying for that kind of stuff. Preferences, we've talked about this. I'm not going to read this again. Make sure you have policies regarding confidentiality. And then how long do you keep the VAWA information? Well, it's 3 years for the period of time specified or the period of time specified in different regulations if you have layered financing like tax credit. Tax credit has vastly and wildly different retention periods than we do at HUD. So adhere to whatever the retention period is for the governing program for that unit. VAWA and HOTMA, we talked about this. VAWA had some new forms just recently released, and the HOTMA final rule says that there's an exception on the prohibition on owning real property for survivors or victims of domestic violence, dating violence, sexual assault, or stalking. So that real property rule under HOTMA, there's an exception to it if you have established that it's a VAWA victim and they are fleeing that real property for their safety. You are not allowed to count that real property against them. That is Section 8 properties only, by the way. Protection for minors. If a minor child within the family is the victim of one of these particular covered crimes, an ownership interest is held by that child's parent or guardian within the household and will not trigger the prohibition of the real property rule. Okay. Confidentiality requirements, restrictions still apply, even if it's a minor. Keep them, because a lot of maybe the parent is the one that's the aggressor. They come in and demand to see all the documentation, and because it's a minor, you think, oh, well, they're the parent, I have to hand it over. No, you do not. You still keep it confidential, even if it's a minor and their parent is the one requesting it. Okay, we made it. I did rush. I'm sorry. We had that little blip thing where my internet went out and I had to get reconnected. But are there any other questions that you have? I know it was rushed. I'm sorry.
No,
but I hope
that's
you
fine.
learned something.
Thank you so much. I appreciate you coming with so much great information. And again, we'll share the slides and this recording. Can you put your email address? Do you mind putting your email address in the chat?
It's right there on the screen.
Oh, perfect. Yep. If people have questions and we can contact you. But yeah, certainly unmute if anybody has any questions. If not, then I hope everybody has a great rest of the day.
Oh, we got one here. Let's see, what is this?
Yeah, thank you, Claire.
Thank you.
Yep, thanks, Claire.
Sorry for talking so fast.
No, that's okay. A lot of great information. Appreciate your time today.
And if anything was confusing, y'all reach out. I'm happy to help in any way that I can.
Yeah, absolutely.
Thanks, Deborah.
All right. Well, I hope everybody has a great afternoon. A great rest of the week.
Bye.